Hello, and welcome to the 7th annual Let's Talk Compliance Conference, which is co-hosted by Foley and Lardner and PYA. I'm Jana Kolarik. I'm a partner in Foley's Healthcare Practice Group, and this is my co-host, Angie Caldwell, Consulting Principal at PYA.
We are so happy to be here. This is our 7th year, Jana, hosting Let's Talk Compliance. 7 years. So we welcome everyone. Thank you so much to Foley and Lardner for partnering with PYA on this event that has gained so much momentum. What started as a quiet little in-person meeting in Jacksonville has now grown to a national conference with hundreds of attendees in each of our sessions. And it's because of the attendance and because of our friends and partners and colleagues that we continue to bring this event to you every year. So again, thank you for attending. And Jana, gosh, thank you for co-hosting with me for 7 years.
Well, thank you, Angie. I mean, it's been a great collaboration with PYA, and we really appreciate it. All the good, not only this event, which again, 7 years is amazing, and I'm very thankful, but also all the podcasts and blogs, etc., that we continue to do together. So thank you to you, and yes, thank you to the attendees. We're happy that you're here. Really appreciate it.
Let's talk about some housekeeping items. So attendees, let's talk about what you're seeing on the screen in front of you. First of all, you can find the slides under the resources window. It is the one that looks like a little cloud on your screen. You can ask questions at any time with the little box that has a question mark in it. You can type your question in there. To the extent the presenters have time to answer questions, they'll do that. If they don't have time or are unable, they will follow up with you perhaps after the conference. All of the windows are resizable, so please feel free to move things around, make your view comfortable for you today in this webinar. And if you run into any technical difficulties at all, your first step is to refresh your browser. So now let's talk about education. So PYA is offering CPE and CHC credits for this event. To be awarded CPE credit, you need to be logged in for the entirety of the session and answer all 3 polling questions. Attendees that are seeking CHC or CLE credit, please feel free to participate in the polls, but that is not required for your CPE credit. Once you successfully meet the requirements for CPE credits, you'll see a CPE certificate available for download in the continuing education window. You'll also receive a copy via email after the presentation. CHC credits will be applied for after the program, and it will take 6 to 8 weeks to process. At the end, you'll also have a survey to answer. Please complete the CEU survey, which will be located on your webinar dashboard.
Thanks, Angie. So Foley and Lardner, for those lawyers on the call, is offering CLE credit. But to be awarded CLE credit, you must be logged into the session for the entire duration of the program. And you must record the 5-digit, we're all familiar with this, CLE code that will be announced later on the attorney affirmation form in the resources panel. You must sign and return the form after the session to LSHC events at lshcevents@foley.com. And then CLE credits will take about 8 to 12 weeks to process, so don't panic if you don't get it immediately. So with that, we'll get to the main event. Our first session today will be led by PYA's Shannon Sumner and Foley and Lardner's Judy Waltz, and they're going to be covering the OIG's General Compliance Program Guidance. And now we'll turn it over to our presenters, so please take it away. Thanks, guys.
All right. Well, thank you so much. We're excited to be back again. I think, Judy, this time last year, I was looking at about 6 inches of snow in Nashville, but for those of us who may have friends or colleagues down in Florida, they may actually have more snow today than we do here. But we're excited to be back and doing this. We had a lot of great feedback from last year, and so we're going to kind of go back and look back in the past a little bit but then look for the future. For those of you who I have not had the privilege of meeting either virtually or in person, my name is Shannon Sumner. I lead our regulatory compliance service line for PYA. Been doing this for a long time. Excited to work with organizations and assessing compliance programs. Sometimes we get involved in assisting if there are some challenges with the compliance program, but today we're going to share a lot of great insights of the things that we've learned over the last year. So I'm going to turn it over to you, Judy.
So good morning. I'm in California and it's still morning out here. I guess it is still in Nashville as well for a bit. So I chair the healthcare practice at Foley and Lardner. We have about 60 or so dedicated healthcare lawyers. And then in our sector, we have a total of about 200 healthcare lawyers, healthcare and life sciences lawyers. So I started my career as a federal lawyer. I was assistant regional counsel at the Department of Health and Human Services. And my practice has always revolved around the federal healthcare programs. So I just want to know, you can look at the number of slides down there, 63 slides. We are going to go through some of them very quickly. And as Shannon said, feel free to follow up with us afterwards if you have questions, but don't get too worried about just that number. So Shannon, you're taking the first part here. So I'm going to turn it back to you.
All right. Well, so what are we going to cover today? We're going to cover, for many of you, you probably have this printed out on your desk. Mine actually has a little bit of coffee stain on it. I dropped some coffee on it last week, but then, got it fixed, got all my notes in here. But we're going to talk about the General Compliance Program guidance that actually was issued back in November of 23. But last year when we did this presentation, we highlighted some of the initiatives, some of the things that you all are familiar with, some of the things that were new. But what we're going to do in this particular session, at least the first half, is that we're going to talk about some of the things that we're seeing, both myself and Judy, as we assist clients, maybe even doing the compliance assessments, and the things that people are doing a great job with, some things that we're struggling, some things that we may still have questions about. And then we're going to get into some of the detailed industry segment specific guidance that the OIG promised that they would be releasing. And the first one since that has been the skilled nursing facilities. And then finally, Judy's actually going to cover a summary of some of the more significant settlements and cases, which really kind of pressure tested the compliance programs over this past year. So let's get started. All right. So why did we call this session Auld Lang Syne? Well, a little bit of trivia here. This is actually a Scottish. It was a Scottish poem from the late 18th century by Robert Burns, and it actually means for old times' sake. Now, if you think about, and for many of us who may sing that song, and it's been a tradition for New Year's. It's really about looking at things in the past. And so that's why we want to do today. We want to talk about things in the past this past year with the General Compliance Program guidance. But, one thing, Judy, I was researching this, and it does talk about reminiscing about old times over a cup of kindness. I don't think they meant coffee, but I think that's probably what we're going to have to do today. So maybe later we'll have a different cup of kindness.
Yeah. I think we plan for that next year in Nashville. Huh?
Absolutely. All right. So we're actually going to our first polling question.
Very good. First polling question is, who performed the best rendition of Auld Lang Syne? Was it the tenors, Dan Fogelberg, Rod Stewart, Dougie MacLean, or Mariah Carey? You're going to have about 30 seconds to answer the poll. Please remember, for the CPE participants on today, you have to answer the polling questions, all 3 polling questions, to get CPE credit. For all others, you please participate in the polls, but it's not required for your CPE credit.
Since I'm not singing it.
Thank you for that, Shannon.
You're very much welcome.
I think Shannon is sending us a signal as to who she thinks the best rendition is. We're going to give folks just a couple more minutes. Please answer the poll.
Oh,
There's
look.
someone that's answering. I'm waiting for the numbers to stop. The numbers are still coming in. Okay.
It's actually a trick question.
Take it away, Shannon.
All right, it's a trick question. And so to my Dan Fogelberg fans, his song was actually the same Auld Lang Syne. So really, he really didn't sing the Auld Lang Syne. But anyway, it's been fun. That's one of my favorite songs. So thank you all who participated.
So what's the correct answer? What's the correct answer here?
It's really, I had some folks say, well, why didn't you put, is it Jimi Hendrix or someone else sang it? I don't know, but we selected just some very odd ones to put on here. But I think a lot of people like Mariah Carey too. So we'll see. Or in this case, it was Maria Carey. So that was truly a false response there. So we're trying to trick you a little bit. All right, so let's get on to it. So as we talked about, this was published back in November of 2023. Great guidance for those of you who have looked at it, worked through it. It certainly was an improvement over the last versions over the last several decades. So well, let's get into some of the details. So as we talked about some of those key insights. So I wanted just to kind of give you a little bit of background in terms of this slide and the next couple of slides related to some of the up and down arrows. As we were putting this together, we're really thinking about the things that we've seen doing compliance assessments. So an up arrow is something that we're seeing maybe an increase. Additional clients are really thinking about this, or it's an improvement over maybe prior years. If it's an equal sign, we're really trying to look at it from the perspective of, is this something that we would have historically seen? Is it consistent with what we're seeing, or is it kind of a non-event? It might be something that organizations had already been doing and continue to do. And then the down arrows are just some observations for, it might be areas that companies or other organizations or health systems or unique types of healthcare entities are really struggling with, or it is something that they're still evaluating. So that's a little bit in terms of kind of the actual arrows and what they mean. So let's talk about the first one. And I think, Judy, this was probably one of the ones that got probably the greatest attention when this was rolled out in terms of intersection of compliance with quality. And at least from the perspective that I've seen and others within PYA, when we do these assessments, we actually are seeing an increase in terms of the intersection with compliance. And that has really been a couple of different, I think the catalyst behind that have been a couple of different things. One is certainly an increase in enterprise risk management, and multiple individuals and departments are really part of that process. So rather than having kind of like the compliance silo and the quality silo and the risk management silo, and we're actually seeing that integration. It's kind of been more of an organic integration we're starting to see. As it relates to the reporting relationship, this thankfully is one where we're really seeing that kind of that steady relationship would be, not be or report to the GC. It is very, it does vary between facilities. Some organizations have a much smaller compliance function, excuse me, a much smaller organization. So we really may not be seeing that. But that's one where it's either been consistent, or in some cases, there's been a greater insight in terms of the separation of that particular relationship. From the compliance committee perspective, related to that member attendance that's included in performance and compensation evaluations, I really haven't seen that in terms of really spelled out in terms of maybe your performance expectations for the compliance committee, or even maybe some additional relationships to, for example, maybe in your performance objectives as well as in your evaluations. I really haven't seen that yet. And as we kind of go through these next couple of slides, if your organization has done that, or they're doing a great job with it, I would love for you all to email me. It's ssumner@pyapc.com. Would love to learn a little bit more about that, because other organizations are struggling with that and want to learn from others as they've been very successful in doing this. Related to the board, one of the components in the General Compliance Program guidance was related to meeting with the board. The compliance officer meets with the board at least quarterly, and also include an executive session. That's something that we're seeing that pretty consistently across all of the organizations where we've conducted a compliance assessment. One area that I have not yet seen done well is related to the evaluation of the actual risk assessment process. In the guidance, it talks about the compliance officer providing a general overview in terms of what is the risk assessment process, but also how effective is the compliance committee or the organization in evaluating risks. I have yet to see where that's part of the reporting up to the board. Hope to see that. That is an area that we generally will have recommendations of, just providing to the board about, here are the risks, here's how the compliance committee is evaluating the risks, here are the different elements of evaluation, and how does that get reported up, particularly as the compliance officers, and in many cases internal audit, present their work plans. I think it's important to note to the board in terms of what elements get elevated to the work plan, what elements are not included on the work plan, maybe because of, having the availability of resources, maybe having the expertise. I think that would serve well to inform the board related to that and really talk about what that risk assessment process looks like. When we have conducted interviews as part of the compliance program assessments of board members, they really want to have a greater understanding in terms of the industry risks. As we all know, sometimes those board members may have various different backgrounds. They may not necessarily be in healthcare, or they may be in a variety of different healthcare entities. They may not necessarily be like a acute care facility. So providing that level of education related to those risks, I think is just going to serve both the compliance function well, and I think it's also going to serve the board well in terms of their oversight. On to the next one. Let's see. So another area that we're seeing a lot of momentum is related to training. And I think from that perspective, it's really ensuring a method for attendees to question content. How we've seen this actually, be operationalized is through some different forums. I have seen some organizations do a Q&A. They do as part of the compliance training and education. They will actually have some feedback mechanisms for those that have attended the training. As a result of some of that we've seen, we've actually seen organizations create like little mini training modules. So if there's a new regulation that's come out, if there's an update to a policy or a procedure, they actually will have a way for various members of a health system or a healthcare entity actually sign up for these really quick, maybe 3 or 5 minute modules. So that is something that I'm really excited to see. For those of us who attend training, sometimes the annual training isn't exactly exciting, but it is something that has to be done. I think through these various different ways to communicate and various different mechanisms, because everybody learns differently. Some people are visual learners. Some people like just those quick hits. Certainly, as many individuals may have been upset because of the TikTok issue, we're learning to get information a lot quicker. And I think that's another area that we're seeing a lot of improvement and some very unique and exciting ways that compliance education is really being disseminated. We're also seeing greater percentage of completion in terms of compliance training. Many organizations over this past year, when we look at the percentage, it's upwards of, in some cases, 100%. I'm not sure if that's always the case, but certainly in the upper 90s. And that includes providers as well. So from the takeaways there, I feel like organizations are really getting the message that this is a requirement and it is a conditional employment obligation. One area that I really haven't seen an organization yet do this is utilize the members of the compliance committee to disseminate compliance education. Now, I have seen it where maybe a member is disseminating information about a policy or procedure that's specific to their particular service line or their department. But what I haven't seen yet is where a member of the compliance committee is part of that training, assisting the compliance team in terms of executing and disseminating some of that training. So again, if some of you have that and could share some great examples of how you've done that, that would be fantastic. This was actually in the General Compliance Program guidance, mainly because it's important for the organization to see that it is compliance is certainly everyone's obligation, everyone's responsibility. And for members of the compliance committee to be able to share that really does articulate that they take compliance seriously. They want to make sure that they are committed to assisting the compliance officer and the compliance team in disseminating that information. Another area that we're certainly seeing an increase is the compliance officer being involved in those compliance investigations where counsel takes lead. From those that I've participated in this past year, great collaboration between compliance and legal, really lockstep in terms of, these are the things from a legal perspective, these are things from a compliance perspective, but in many cases they are sharing in that, they are working together, they are collaborating. So this is one area that I've really seen a great increase over the last year, at least over a couple of years. One area in terms of incentives for compliance. This is, I would love, again, to see any examples of where those of you who are participating today have done a great job. When we do talk with senior leaders, we talk with governance about tying some level of incentives, bonus structure to the compliance program. I do get a lot of great feedback related to what exactly does this look like. One area you really don't want to do is incentivize everyone who makes a phone call to the hotline. That's not what you're trying to incentivize. Some executives and board members that I've talked to about this, they also want to explore, is this, maybe a trigger for incentive comp? Is this what metrics or measures would you be, anticipating for demonstrating an effective compliance function? That really, in my opinion, has to be something that organization, everyone's organization is different. They have different, mechanisms for incentivizing. And that needs to be something that needs to be discussed, whether it's, a combination of HR, compliance, legal, certainly senior leaders. What exactly does it mean to be incentivizing ethical and compliant behavior? Many will say we talk about that in our code of conduct. There are certain disciplinary actions related to compliance. But one area that I really haven't seen is really tying this back to, senior level executives. And I really haven't seen clawback provisions. Certainly in some of the corporate integrity agreements, maybe for pharmaceutical, there are certain requirements for that. But I haven't, and Judy would certainly love to hear from you if you've seen any of this as well. But that's one of the areas that I know was discussed in the General Compliance Program guidance. This is something that I don't think could happen overnight, but would need to be explored a little bit further. Oh, Judy, you're on mute.
So let me just make a quick comment. I have not seen the clawbacks, but I have seen now, particularly with corporate integrity agreements and some places that are a little bit more aggressive in terms of their compliance efforts, where they are putting the executive's name on the line so that there is some sort of attestation, or if it's not that formal, some sort of confirmation that they have looked at the compliance program and as it relates to their particular responsibilities, and that they're comfortable that they are in compliance. And of course, those would set them up well for clawbacks in the future should something prove to be not as first perceived, if somehow it was their fault. So I do think we're seeing more aggressive stuff, but clawbacks really is at the far end of the spectrum, and difficult to convince people to sign up for.
Yes, absolutely. Thank you. So a couple of other compliance considerations that we talked about. As we mentioned earlier, I think quality and patient safety was probably one of the ones that I think garnered the most attention in terms of how do you really integrate it. We have seen an increase in this over the last year, at least from my perspective. And it really does go back to that collaboration with various departments, that are accountable for mitigation of risk, whether it's clinical, quality, patient safety, compliance, all the different kind of risk assurance providers. And I think that has a lot to do with, we're seeing a lot of investments in enterprise risk management. Again, it's more organic. I'm starting to see some compliance work plans with other additional elements that include some type of quality component. Again, it's working in collaboration with what are those top risk areas that would, resonate on your compliance work plan. Another increase that I've seen is certainly one of the recommendations is that the board requires those regular reports from senior leadership with quality and patient safety oversight in conjunction with the compliance officer reports. Where I have seen this work effectively is when they do have, certainly they have a compliance committee, and in many cases, the compliance officer might participate in that compliance committee, and that quality committee report out to the board. Again, it's integrated. There certainly is the understanding that there should be that additional evaluation of an incident in terms of, is there a quality component to it? Is there a compliance component? Is there a billing issue? Is there a regulatory issue? And that is something that we are starting to see more and more because of that interdisciplinary approach to reviewing any type of maybe a patient incident or a safety harm event that occurred. I think this also ties in with the third kind of up arrow related to the compliance committee, including members responsible for that quality assurance, patient safety, and that adequacy of the patient care. Again, that roles that they work very closely together. Many committees have been established, if not already established. So I think this was one where, I don't know if it was something that, because it did come out in the guidance that was so kind of at that point kind of earth shattering, I'm really not saying that that's been a challenge for many organizations. Again, would love to hear from some of you who may see that still as a challenge. But as more and more of these organizations are having those risk assessments that are being done and done holistically, this is something that is organic. Compliance work plan includes quality audits and reviews. As I mentioned, I'm seeing some of that. I'm not seeing a whole lot. But if within the compliance committee and the quality committee, and they are reviewing those types of incidents, I think this will be a natural event as well. I'm not really seeing the compliance committees as part of the assessing of the nursing, therapy, and clinical service staffing. Again, I think this is something that would be handled with that quality committee. I know Judy and I, have talked about that we feel that that's really where this should be, but with that integration with compliance, if there is any type of regulatory compliance impact. But on the flip side, we are certainly seeing those productive, collaborative working relationships with those clinical and quality leadership. And I think the information sharing has certainly enhanced over the last couple of years. Any thoughts on that, Judy, that you're seeing? Oh, you're on mute.
Sorry about the mute. I keep forgetting that I put it on. Shannon and I have had talks about the intersection of compliance and quality, and me being a lawyer, I'm protective of the organizations, and there are a lot of different streams to try to protect people who come forward with compliance concerns. And from my perspective, compliance has more of a focus on transparency, whereas quality reporting sometimes needs to be not so transparent because people don't want to come forward otherwise if they aren't feeling that their disclosures are going to be protected. So for me, this is still an intellectual challenge. We worked with one client recently on trying to design policies and procedures that would protect people in terms of coming forward and provide some privilege, at least attorney-client privilege protection in the early stages. So in any event, I struggle with the merger of these two concepts, but I may be the only one that is struggling because Shannon has lots of good ideas how to implement this.
Yeah, I'd love to hear from the audience as well. But again, I feel like it's being addressed in various forms through quality committees, risk, patient safety, and in some cases we have compliance officers who serve in multiple roles and multiple hats, and And that is an area that I will continue to see, particularly for some of these smaller entities.
And let me just add one more little story here. So there was a lot of press around a case that involved a quality issue, a physician who was performing, it was either unnecessary surgeries or dangerous surgeries. Maybe they should have been performed, but they weren't being performed in the way that he was performing them. So there was an assistant U.S. attorney who was investigating the quality issues as False Claims Act matters, and actually called the hospital to say, I'm sure we're looking at this guy and his practices. And then later the hospital was the defendant in a False Claims Act suit with the U.S. attorney's call being used as evidence of knowledge or at least reckless disregard. So it just seems like there are a lot of different streams going on. This doctor was being investigated by the hospital through its usual process. So anyway, it is something that in my mind is not perfectly aligned.
More to come, I'm sure. And then for those of us who are going to HCCA Compliance Institute, I'm sure there'll be some additional dialogue there as well. A couple other items, and then certainly want to turn this over to Judy with what time we have. As it relates to the compliance risk assessments, one of the recommendations related to, just ensuring that medical necessity, patient safety, and quality issues are included in the risk universe. Absolutely. Again, this is one area as those risk assessments are being more approached more holistically with various constituents. We're seeing a lot more of those work plans, including these particular areas. Certainly in areas where you have new technologies, medical devices, those are just things that will come hand in hand, in my opinion, between the compliance team and the quality team in determining what should be on a compliance work plan. The next two areas, fraud, waste, and abuse, and also the private equity and other private investors, where it talks about new healthcare industry entrants and new models of care, really requiring that understanding of fraud, waste, and abuse laws. That to me also goes well with the concept of following the money as it relates to new entrants, private investors. Just from our perspective, we are seeing more organizations engage consultants, legal counsel for evaluating compliance issues through due diligence exercises. More and more, I feel like the PE-backed organizations are starting to better understand the compliance issues that could be present in any type of new initiative or acquisition, particularly if they're new to healthcare. If they have a portfolio company that's in healthcare, but they may not be part of a healthcare conglomerate per se, they're starting to see more and more of those opportunities to evaluate the compliance ramifications of any type of new entrants to care. And then finally, this is the one that I would love to see more up arrows related to financial arrangements with referral sources. This is consistently an area from, if you evaluate corporate integrity agreements, if you evaluate any types of settlements, relationships with referral sources are not getting any less complicated, especially if you have additional areas where you are maybe participating in joint ventures with providers. If you have some innovation centers, there's a lot more types of equipment and medical devices, as I mentioned, that's out there. And these all can have that type of fraud, waste, and abuse and a kickback and stark implication. So I would love to see more organizations have these on the compliance work plans, taking a sample of arrangements, looking at corporate integrity agreements. And in many cases, it's Appendix A in terms of an independent review organization for CIAs that do have that type of focus arrangement bent to it. Take that, look at it, follow the steps, pull samples. From a legal perspective, the contracts can be fantastic on paper, but sometimes they could fail in execution. So if you haven't considered this for your compliance work plan, my recommendation would be making sure that you do. And then just finally, in the last minute or two, in terms of implementation best practices, as I mentioned, I feel like we're seeing a greater demonstrated engagement by the compliance committees, both at the board and at the entity level. We're seeing, again, kind of the enterprise risk management with the active engagement by various parties. And then just real quickly, in terms of number 8, this is one of the one that I guess I, as an auditor, former auditor, I got the most excited about, where an organization actually had gone into some of the high risk areas and actually came up with an inventory of the top 3 to 5 risk areas that are being monitored by that particular department. And they actually had this amazing spreadsheet of all the different high risk areas and the 3 to 5 areas that they're monitoring. And that is the kind of information that got elevated to the compliance committee. So this was one that really I was really excited about as an auditor, as a geek. And for our fellow geeks out there, we unite on this one. So I am going to turn it over now, I think, to Jana for our next polling question.
Yeah, happy to take it. So for poll question 2, it's my organization has considered or implemented the following GCPG recommendations. First is performance measures for members of the compliance committee. Second, incentive triggers and or clawback provisions related to compliance violations. Third, greater engagement between compliance and quality. Fourth, all of the above. Fifth, none of the above. So again, just a reminder, to be awarded CPE credit, you must be logged in for the duration of the session and you have to answer these polling questions. And for those getting CLE or CHC, we would really just love to see your input. So please do answer the polling questions. So we're still coming in steady.
So while we're waiting, I know we always do this, Judy, useless trivia. Today is National Security Technician Day. It's also National Handwriting Day. And I'm like, how did they come up with National Handwriting Day? It's the Writing Instrument Manufacturers Association.
Very nice.
So it's whose manufacturers? The writing?
The writing instrument.
Oh, like pens?
I still own a pen and I own a piece of paper and I still write. And I wondered about this because it's also John Hancock's birthday. So he was the first signer of the Declaration of Independence. I wonder if that's why they picked today.
Very nice.
Picture John Hancock there. So there you go. You all can win now at trivia contests.
Yeah. Not to brag, but one of my distant relatives was a signer of the Declaration of Independence.
You can brag. That's brag worthy. All right, guys. All right. I think the polling responses are in.
All right, thank you. Well, this is exciting. Greater engagement between compliance and quality. And for those that have those incentive triggers and performance measures, would love to hear from you. That's pretty good percentage, actually. All right. Take it away, Judy.
All right. So we're going to go to the next part of our presentation, which has to do with the first segment-specific compliance program guidance. And that is on the nursing facility industry. So we're not going to cover this in as much detail as Shannon's discussion of the general compliance program guidance. This is a specific one for nursing facilities, and I recognize that a lot of people on this call probably don't work with nursing facilities, but it is important because it's the first one out, and we can take a look at what we can expect, both in terms of format and what OIG is going to be focused on, or at least what they were planning to be focused on. I, as a former federal employee, have been watching very carefully the executive orders that have been coming out, and it's not clear to me what direction we're going to be headed in. There were some discussions yesterday on HHS communications being held up for the next 60 days or so. So we'll see how all this plays out. But back to this specific compliance program guidance, this was not the first one that we were expecting. When the general guidance came out, OIG had said next up would be managed care they just said managed care. I clarified with them they meant managed care plans, not those providing services to managed care, although from my perspective, that's another emerging issue. So there was, for reasons I am not privy to, instead the nursing facility guidance came out. This is consistent with the focus that OIG has had and DOJ has had on nursing facilities. The terminology is one that, back as a government lawyer, I once spent many hours on the difference between SNFs and NIFs, and basically, as contemplated by CMS, and you can see here the sites that will explain this, a skilled nursing facility is under Medicare, nursing facility typically Medicaid or Medicaid only. This guidance applies to all sorts of facilities. This is how they define nursing facilities. So just a couple background points on this. It was issued in November of 2024. And I've talked about how this will be the first in series. This one, we just talked about the relationship between quality and compliance. The focus of DOJ and OIG on nursing facilities has largely been on quality issues. And what's interesting is that CMS has its own requirements of participation, used to be called conditions of participation. I know some of my colleagues at OIG, or well, actually at HHS in the Office of General Counsel, spent a lot of time discussing the terminology and the conditions of participation versus requirements of participation. One of the things noted in this guidance is that nursing facilities are in a unique position in that they are focused both on the quality of care and the quality of life. I've included a quote here on quality as a compliance concern. OIG feels very strongly that quality and compliance need to be merged. So I am in a minority, I think, in terms of still expressing some concerns about that. In case you're interested, and OIG talks a lot in this particular document about quality of care CIAs. So if you're interested in seeing them, they are listed separately on the OIG website. There's just a handful of them right now, and you can see them here. If you are trying to design a quality program, you may want to look at what the requirements were in terms of these CIAs. And you'll also just see so many references in this guidance back to these CIAs that were entered into because of quality issues. So one of the things that OIG does in this document and had been promised in the general guidance is that they would identify specific risk areas for each sector that has a new OIG program guidance issued. So here, I'm not going to go through all of these because they are specific to nursing facilities. I'm just going to highlight a couple of them, not on this page. Appropriate use of medications. Now, why am I focusing in on that? This one goes beyond quality, and they talk about a potential conflict of interest with pharmacists and pharmacies and the possibility of kickback issues. And so this shows, again, from my perspective, the intersection of quality and compliance and why you need to protect the quality side as well. These are specific to nursing facilities. The resident safety is one that we've talked about, that they are looking at this both from DOJ and OIG perspectives. This staff screening is what I'm going to come back to outside of this, but if the facility submits claims for an excluded provider providing items or services, payments and overpayment, and they recommend screening. So we are going to get back to that in just a moment. We have polling question number 3.
Polling question number 3 is, the OIG's Nursing Facility Compliance Program guidance applies to skilled nursing facilities, dually certified facilities, single facilities, chains, managing and operating companies, or all of the above. Remember, for our CPE participants today, you must answer all 3 polling questions and stay attached to our webinar today for the entirety for its duration. CHC and CLE folks, please participate. We'd love to hear from you, but responding to the poll is not required for your education credit. We've got some participants coming in. Shannon, do you have more trivia?
I do. Today is National Pi Day, not 3.14, but PIE Day. And I did not see the sponsors of the National Pie Day, but they did say to give a shout out to your local bakery. So everyone needs to stop by and get a piece of apple pie or cherry pie. My favorite is coconut cream pie.
It's getting close to lunchtime here on the East Coast, so well timed.
And that's more understandable than writing instrument. Just go with pie.
Well, there's the National Security Technician Day.
Yeah, I still don't know what those. No, never mind.
All right. I think we're wrapping it up here. Thank you for responding to the poll.
Thanks, Angie.
All right. So back to the more generic points from the nursing facility ICPG. I just want to point out, this is a screenshot that came from the guidance, and OIG has helpfully listed the most relevant safe harbors that might be involved in an analysis of issues that are presented to nursing facilities. And note they have little links here. So as a lawyer, instead of keeping all of these and trying to find them separately, I really appreciate that OIG has done this. So OIG's come up with what I think is a new risk area term, which is tunneling, which when I saw that, I had not heard of that. If you do see it somewhere, then you can go back and look at their definition. It basically has to do with related party transactions that, of course, OIG is convinced is not appropriate. And on some cost reports, of course, you can't even claim, or you have to discount the cost, your profit for related parties. But anyway, just tunneling is a term that I have not seen before. The other thing, and Shannon mentioned this a little bit with the overall general compliance guidance, there's a focus on investors, and I think we're all sensitive to the focus that OIG and to some extent DOJ have put on private equity. And so here again, OIG is repeating its concern about investors and including them as responsible individuals. Here we have an example where they're referring back to the quality of care CIAs, and they're linking it into investors. CMS has actually published in the preamble of at least one of its rules a survey of literature that relates incidents related to private investor owned and operated facilities, which is very surprising to me as a former government lawyer. It is surprising to me that they have focused in on this sector and with such energy. The other thing I just want to point out, I'm not going to go through this, again, another section of this guidance provides a reimbursement overview, which is also very helpful. People who've worked with us know that with this sector, know that nursing facility reimbursement methodologies have changed and evolved over the last few years, and this is just really a helpful overview. So now I'm just going to go into some miscellaneous things. Last year, we talked about state exclusion checking, which is mentioned in the general program compliance guidance. And following our presentation, we got the most questions about this particular topic. So this is in addition to the names that are on the OIG's exclusion list. Federal regulations allow a civil monetary penalty if someone is excluded, and that would be both from, well, typically it would be both federal and state, but states have their own provisions, and a loss of billing privileges, for example, which is not an OIG exclusion, but done through CMS, can also result in a termination. So this is state exclusion checking is kind of a pain in the neck because each state has its own provisions. I think the number is now up to about 43 different lists that you have to check, and then a few that don't have them. So in addition to the federal CMP that we just referenced, there can also be state specific provisions, which, for example, we have in California, that an entity that employs or contracts with excluded entities can itself then, if it submits claims, can itself be subject to state CMPs. Another thing I want to just point out is that there is a statutory change that requires states now to report exclusions, or whatever they're calling them, and each state has its own terminology. They have to report in a certain amount of time, or there can be an impact on the federal financial participation funding that they receive from the feds. Each Medicaid program receives a certain amount of, or a certain percentage of its budgets from the feds. And since that statute went into place, I personally have seen a number of collateral terminations from where an entity is excluded in one state, and then a second state piggybacks on as it is required to do, and then Medicare may piggyback. Medicare then has the discretion to piggyback on with a billing privileges revocation. So I've seen this become a much more active way. So there's also a preclusion list that applies to Medicare Advantage and Part D. That's separate from the OIG list, but an individual or entity that is on the preclusion list, if claims for their items or services are submitted, they're not going to be paid, or if they're paid, they're going to be an overpayment. So this is from my perspective, this is a high risk area, and one that now is increasing in enforcement. So I know we're getting short on time here. There was a recent revision to an existing statute that's being called the Administrative False Claims Act. To my knowledge, this has never been used by HHS, and I don't know if they would. It basically increases the limit of cases that can be handled through this provision, like through the agencies, to $1 million from $150,000, and it could be another avenue for enforcement activity, but we will have to see. Given our timing, I'm going to skip this section on significant cases. Loper Bright is the one that overturned the Chevron deference. These are all Supreme Court cases. Jarkissi questioned the ALJ process and said that in some cases, entities would not have to stick with an ALJ, but could go for a jury trial. And Corner Post establishes an injury-based statute of limitations. All these are going to be discussed at session 4, I think it is, of this PYA thing. They will be discussed in detail there. And you can see here the slides, and call me if you have any questions. So I want to get to just a few cases, a few random cases that, from my perspective, show some risks associated with compliance programs. So first, and we have the links here on all of these so you can read more about them. So this is against both the group and the CEO. And these were services furnished outside the United States. And that is an exclusion from Medicare reimbursement. So I know a lot of people are outsourcing and using, in some cases, foreign countries. There are implications that go along with that. So be sure to check on those as a compliance risk. This one, not sure why it says preview there. That was not not my edition, but anyway, it's very, very visually appealing. So anyway, this is an indictment. So through the criminal process for unnecessary surgeries, and the inpatient, this should be the inpatient only rule, the IPO rule. This demonstrates a return of the government to medical necessity cases, which they have gotten away from for a few years because they're hard to prove and subject to a lot of dispute. But we're back with a number of cases reported in various settlements and other activities like this indictment, indicating medical necessity is back as a significant enforcement risk. Here's another indictment. So here's one. This is a sentencing, and you can find the link to the prior case as well, to the prior press release about the case when it was first brought. This involves incident to services, which are always difficult to document, and another compliance risk. And here's a guilty plea for the senior partner of a consultant for obstruction of justice. And this is McKinsey and Company. There was also a settlement by the company and involved advice given by the consultant for compliance or investigations related to opioids. Here's another one on personal accountability. It has to do with the lab director. So I do a lot of lab work, and lab directors are really focused on the clinical side and compliance with CLIA. They are required under CLIA, but now they are also being named as defendants when something goes wrong. And so this is another risk for lab directors, and also demonstrates, I think, personal accountability as a focus of DOJ. And then finally, an OIG self-disclosure that related to a civil monetary penalty where the incorrect rendering provider was identified on the claim form, or the services did not meet coverage criteria. So this was a self-disclosure, and a relatively small amount, but does indicate the importance of doing things appropriately. And I think we are getting close to the end of our time. And I know we have another session following us. So I'm going to turn it back to Jana to wrap us up.
Very good. I'm going to jump in here. Thank you so much, Judy and Shannon, for your time today, for sharing your expertise. It was very informative and entertaining. Thank you so much again for your time. Attendees, please complete the CEU survey located on your webinar dashboard. If you want more information about Let's Talk Compliance, you can find that on the Foley website at foley.com/insights and pyapc.com/insights. We look forward to seeing you again, hopefully in 30 minutes at session 2 of Let's Talk Compliance. Janet?
Thanks, Angie. So for those of you attending, the CLE code announcement is on screen, so please take note of it. We, again, hope you enjoyed the discussion today with Judy and Shannon. For more information on compliance topics, please check out our Let's Talk Compliance podcast series by visiting healthcarelawtoday.com and searching Let's Talk Compliance. On behalf of Foley and Lardner and PYA, thanks for joining us. And we have our second session on privacy and security trends beginning at 12:30 Eastern, and please join us then. Thank you, Judy and Shannon. So appreciate it. Great presentation. Thanks so much.
Thank you. Thanks, everyone.